immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to this special edition webinar hosted by immigrationquestion.com, a networking platform meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. My name is Nikita Bahadur and I will be your host for today's important discussion, naturalization and citizenship requirements. For many lawful permanent residents, becoming a U.S. citizen is an important milestone. However, the naturalization process involves detailed eligibility requirements, strict residency rules, and careful review of an applicant's full immigration history. Understanding these requirements before filing can help avoid delays, denials, or complications. Preparation and awareness are essential, especially for applicants with extended travel history, prior immigration histories, and complex backgrounds. To help us break this down, we are honored to be joined by attorney Ibrahim Caglar, an immigration attorney who advises lawful permanent residents on naturalization eligibility, compliance consideration, and citizenship readiness strategies. Attorney Caglar, thank you so much for joining us today. We're thrilled to have you on this important discussion.
Thank you for inviting me.
Before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or another platform, welcome. Please subscribe and share the session with lawful permanent residents who may benefit from understanding the naturalization process. Let's dive right in. Attorney Caglar, what are the basic eligibility requirements for naturalization?
So the first question we always get, and it is the right place to start, is what are the basic eligibility requirements for naturalization? The starting point is that you must be at least 18 years old at the time you file your application. And you do that with a form called N-400. And next, this is the big one. You need to have been a lawful permanent resident, a green card holder, for at least 5 years. Now, there is an important exception to this rule, which is if you obtained your green card through marriage to a U.S. citizen and you are still married, then the requirement drops to 3 years. During this period, you must demonstrate that what we call continuous residence in the United States. You also need to show that you have been physically present in the country for at least half of the required statutory period. So when I say statutory period, that means that either it's 5 years for those who have been lawful permanent residents without, I mean, for those who have the green card and they obtain their green card without getting married to a citizen, like maybe employment sponsorship. But if you get your green card through marriage to a citizen, the statutory period then becomes 18 months. And you also need to have lived in the United States or the USCIS district where you're filing for at least 3 months before you submit your application. Then there are the character and civic requirements. You must demonstrate a good moral character and have a basic understanding of US history and government, and be able to read, write, and speak basic English. And finally, you must be willing to take the oath of alliance. These are the building blocks of naturalization application. They sound simple on paper, but as we are going to see today, that the details matter.
And what are the factors can break continuous residency, and how can applicants address these concerns?
This is one of the most common issues I see in my practice, and it is one that catches a lot of people off guard. Continuous residence means that that the United States has been your primary home throughout the statutory period. It doesn't mean you can never leave the country. Of course, you can leave the country for vacation, for 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 a short amount of time, but the time that you spend outside of the country and the nature of your absence matters. Here is the general framework. If you are outside the US for less than 6 months at a time, you're generally fine. USCIS typically won't question those shorter trips. If you're outside the United States for more than 6 months, but less than a year, you got a problem. If you're outside the US more than a year, you got an even bigger problem. But let's talk about this first. You're outside the US for more than 6 months, but less than a year. It is not necessarily fatal, but at that point, USCIS presumes that you've broken your continuous residence. But here is the key. This presumption is rebuttable, meaning that you can show evidence to convince USCIS that you did not abandon your lawful permanent residency here, but you have to have a documentation. I mean, you need to show that that you did not abandon your residency, and you can overcome this presumption by showing that you maintained strong ties to the United States during that travel. And we're talking about things like maintaining your home, so you can show your lease, keeping your job, paying taxes. This is very important, and having family here, and any evidence actually that shows that you that U.S. Remained your primary residence, primary base during that travel. Now, if you're outside the U.S. for more than a year, that's completely different, and that's going to be a bigger issue, as I said. My advice to clients always is this. If you know you're going to be traveling extensively, when I say extensively, more than 6 months, you should talk about it before. You should talk about before you travel with an immigration attorney, and it is going to be very important for your naturalization application.
And Attorney Caglar, good moral character is a key requirement. So, what types of issues can affect one's eligibility?
Good question. Good moral character is one of those requirements that sounds subjective, and to some extent it is. But USCIS has pretty clear guidelines on what they're looking at. The statutory period for good moral character mirrors your residency requirement, meaning, generally speaking, 5 years. So if you're a 5-year applicant, USCIS is going to look at your conduct during those 5 years. But this is important. They can also look beyond that period if there is a reason to, and they usually do. They have access to a lot of information. So this is important. Let's talk about what can create problems, right? First, and most obviously, criminal history, especially certain offenses. We call them what we call them permanent bars to establishing good moral character, such as aggravated felonies and murder. So if you have conviction like that, its naturalization is off the table in most cases. And then there are conditional bars, offenses that prevent you from showing good moral character during the statutory period, but don't permanently disqualify you. These are like controlled substance violations, 2 or more offenses with a combined sentence of 5 years or more, certain gambling offenses. But these can be overcome. Criminal convictions aren't the only concern. USCIS also considers things like failure to pay court-ordered child support or alimony, and lying under oath, and failures to file tax returns or pay taxes. And I'll talk about this in detail later, but this is important that I see it in my practice a lot, that people are not, the applicants are not really thinking that this is going to be an issue, but it does. So if you haven't been filing your returns and you owe back taxes, get that resolved before you apply. The good news is that for many of these issues, there are legal strategies that we use, but you have to assess them honestly and plan accordingly. The worst thing that you can do is like coming to a naturalization interview with an unresolved tax obligations or one of the things that I just mentioned, or like undisclosed arrest, or it's the worst thing you can do. So you have to plan accordingly before.
And what should applicants expect during the naturalization interview?
I think the naturalization interview is one of those things that people build up in their minds, and understandably so, of course. It's a big moment. You're becoming a U.S. citizen, that you lived in this country for a while now. And if you're prepared, it's very manageable. Let me walk through what actually happens. When you arrive at the USCIS office, you'll check in and wait to be called. An officer will come to get you, and the first thing they'll do is put you under oath. Everything you say from that point forward is under penalty of perjury. So, like, you should just directly answer the questions that you've been asked to, and also be careful. The interview itself has several components. The first component is that the officer will go through the application question by question, usually, and they're verifying your answers and looking for any changes since you filed, because it takes some time for them to schedule the interview. So they're looking for changes, and this is why I always tell my clients, review your application. I try to review the application with them a night before or 2 days before, so that they know what is in the applications. And if something has changed, we make a note of that change, like such as new addresses or new job or something like that, and you can update those with the officer. Second, you'll take the English language test, which has 3 parts: reading, writing, and speaking. The speaking component is really assessed during the interview based on your ability to communicate with the officer. For reading, you'll be asked to read 2 or 3 sentences in English, and for writing, you'll write 1 or 2 or 3 sentences that officer dictates to you. Very straightforward, I think. They're basic sentences. Third, you'll take a civics test. And there is a change that I want to talk about here. After October 20, 2025, there is a new civics test consisting of 20 questions from the list of 128 questions that you can find on USCIS website. And you must answer 12 questions correctly to pass the test. But if you filed your application before October 20, 2025, you'll be asked up to 10 questions from the list of 100 civics questions, and you need to get at least 6 right. The questions cover American government and history and like civic values. These questions are published, and the full list of questions are published on the USCIS website. So you should study them. And there are disability waivers for English and civics requirements. At the end of the interview, the officer will generally tell you the outcome. And you'll be scheduled for a naturalization ceremony, which might take in the same day, but that depends. Yeah.
And how does USCIS evaluate misrepresentations or inconsistency in early immigration filings when reviewing a naturalization application?
Important question, I think, because this is where things get really serious. And I want everyone to pay close attention. When you file an N-400, a naturalization application, USCIS doesn't just look at the application in isolation, right? They pull your entire immigration file. That means every application you've ever filed, every interview transcript, every supporting document. And they compare what you are saying now with what you have said in the past. If there are inconsistencies, they're going to ask about them. And this is where the stakes get high, because misrepresentation in the immigration context isn't just a naturalization issue. It can become a ground of inadmissibility. Very serious. Let me give you some examples. Maybe someone listed a different work history on their green card application than what they're saying now, right? So maybe they didn't disclose a prior marriage. These discrepancies don't just raise red flags for the naturalization application, but they can trigger a full review of whether the underlying green card was properly granted. That's very important, right? And here's the part that scares a lot of practitioners. USCIS has the authority during naturalization proceedings to reopen or re-examine the basis for someone's permanent residence. And if they determine that the green card was obtained through fraud or material misrepresentation, they can deny the application and initiate removal proceedings. So instead of becoming a citizen, the applicant could end up in immigration court fighting for their green card. This is very serious. So the takeaway here is this: honesty and consistency are absolutely critical. If there is a disparity in your record, the worst thing you can do is ignore. Right? You should definitely consult with an immigration attorney, address it proactively with your attorney before you file. And even like in some cases, I would advise to not to file. Like depends on the, of course, case, but very important. Thank you.
And for applicants with complicated histories, when might be risky to apply for naturalization and what should be assessed beforehand?
Okay, these two questions are, I think, related. So not, I was just saying like, in some cases I advise to not to file, right? So not every lawful permanent resident should rush to file for their naturalization. I know that might sound counterintuitive, but most people assume that becoming a citizen is always a good thing. And generally it is, right? But there are situations where filing a naturalization application can actually put someone at risk. And here's why. When you file the N400 the naturalization application and form N400, you're essentially inviting the USCIS to take a very close look at you and your immigration history. They're going to review your entire immigration history, your criminal record, your tax compliance, your travel, everything. I will give you an example that my client that we filed a naturalization application this year, and my client has been a resident over 10 years. So it was time, and we did the assessment, and we said, okay, we can file without issue. And we filed, and we received an RFE, right? And we were like, what is this RFE? And it was an RFE when he was a student here. He had a traffic arrest, and he forgot about it. Like, honestly, he didn't remember that he did have that arrest. But what I'm trying to say is that we took care of it, and he was naturalized. He's a citizen now. But all I'm trying to say is that when you are filing a naturalization application, they're going to take a look at your immigration history, your criminal history very closely. So just be prepared. And if something in that review raises a concern, you can't just withdraw the application and walk away as if nothing happened, because USCIS can, they can of course deny the application, but they can, and in some cases they issue notices to appear in removal proceedings, of course, based on the information that comes to light during the review. So who should think twice, right? That was the question, I think. So let me walk through some categories. The first category that I want to mention is that anyone with a criminal history. Definitely, it should be, the criminal history should be analyzed by an immigration attorney, and in some cases by a criminal attorney. That some attorneys are specialized in both, so that is something that you should consider. Second, anyone who may have committed a fraud or misrepresentation in obtaining their green card. If there are issues, not necessarily like you believe that you haven't committed any misrepresentation, but you should still review your immigration history and before you file your naturalization application. And third, people with significant tax issues, unfiled returns, large outstanding balances, or unreported income. It's going to be an issue. For anyone who may have accumulated unlawful presence before getting their green card, or if they traveled outside the country more than 6 months they should review their history with an immigration attorney before they file. And fifth, individuals who have any pending immigration issues, maybe they should address those issues before filing a naturalization application. And my strong recommendation is this: if you have a complicated history, do a detailed pre-filing assessment with an experienced immigration attorney. And if you have a criminal history, then you should definitely have an assessment of the criminal history and the implication of those, the history on immigration. And then this is going to be very important. So a lot of attorneys do this, but we do this regularly in our practice. We review the client's full history, and we identify potential issues and develop a strategy. And in some cases, like in terms of like filing now with a plan to address those concerns, if there are concerns, or waiting until certain issues age out, because of course, the USCIS can look at whole history, but the most important part of your history will be the 5-year statutory period. In some cases, we can decide that maintaining permanent residence status is a safer path than filing a naturalization application.
Thank you so much for those insights. For everyone watching, this discussion about naturalization and citizenship requirements is not meant to create concern, but to encourage careful preparation and informed decision making. The naturalization process requires a full review of residency history, travel records, prior applications, and conduct. Understanding these factors before filing can help applicants move forward confidently. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration-related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Attorney Caglar, based on your experience guiding clients through naturalization, how does ImmigrationQuestion.com help immigrants and attorneys like yourself?
Thank you. I love this platform. It is great because it brings attorneys, immigration attorneys, and immigrants together to share information, to update immigrants on certain issues. Because immigration law changes if I say every day, I'm not exaggerating. It really changes every day. So thank you for doing this. Thank you.
If you're just joining us, we've been speaking to Attorney Ibrahim Caglar on naturalization and citizenship requirements. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insights from a licensed immigration attorney. Please drop your questions in the chat or call us live on 516-703-3483, and we'll take as many questions as time allows. Our first question: what types of criminal records should stop me from becoming a citizen?
Good question. But usually two types of criminal records can stop you from becoming a citizen. What we call them permanent bars, aggravated felonies, and murder.
Okay. The next question: my Nana is 68 years old. Will she still take the English and civics test?
Good question. But yes, you will. There are waivers that you can request from USCIS, but applicants who are 65 or older and who have been permanent residents for at least 20 years, they get simplified civics test with a shorter list of questions. So they, the USCIS tries to make it easier for them, and they are disability waivers available for English and civics requirements under certain circumstances, but they require medical examination by an MD, by a doctor. So,
okay, our next question. Does USCIS interview every applicant for citizenship?
generally, yes. Yeah, I would say yes. Yeah, because you have to take the test. You have to. Yeah, but if you have a waiver, then you might not be required to have an interview, but they will still review your waiver. Yeah.
Okay, so that's all the time we have for questions today. Attorney Caglar, recent reports indicate that fiscal year 2027 H-1B cap registration period will be open March 4th and run through March 19th. The annual cap registration process remains a critical pathway for many foreign professionals seeking employment-based status in the United States. Attorney Caglar, when immigrants hear about the opening of H-1B registration period, how would you advise them to stay informed and properly understand the potential impact on their broader immigration journey, particularly for those who may eventually pursue permanent residence or naturalization?
So for those who want to register, or who have a sponsor who can register them for H-1B this year, the first thing that I would say, it started. Okay, it started yesterday, so it's gonna the registration period is from March 4th, starting yesterday, through March 19. So this is, if you don't miss this, it's a great opportunity, and you should definitely, if you want to, there are a lot of information out there, but if you want to get the, like the I would say always follow the USCIS website, because you will get the updates from them directly. That's so you don't get confused. And this year is going to be a little bit different from previous years. First, I know that a lot of there's a lot of confusion about what the 100K fee rule, about the 100K fee rule, who's going to be subject to that rule, and the just generalized, generally speaking, like, it's not going to apply for those who are applying within the United States. So if you're in the United States and if you're planning to apply, take that opportunity to apply. And second, it's going to be different this year, is that there will be wage. Your wage will make a difference this year. USCIS will conduct a weighted selection that will give higher odds of selection. So it's not going to be just a random lottery, a traditional random lottery. It will give a higher odds of selection to beneficiaries, like being offered higher wages. So, and there are wage categories that you can check on USCIS website. So this means that in practical terms, H-1B landscape is shifting to favor higher paid, higher skilled positions. So employers are going to need to provide the Department of Labor's occupational code. I mean, this is technical. I don't have to get it to go into details of this, but it is going to be important. So, and one practical tip that I will give is, if your wage is very close to the next higher wage, you should ask that raise now, because it will give you a higher chance of getting the H-1B lottery. So, yeah.
Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Caglar, for sharing your knowledge and practical guidance.
You're welcome. Thank you for inviting me.
You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of today's discussion, the replay will be available on Spotify soon. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday on our next live session. Stay informed, stay prepared, and stay connected.